Hi there, welcome to another episode of Youth Connect. My name is MFA Kosiadeti, so let's get straight into it. I'm in a rather good mood today. Why? Because as a BIM native and the amount of awards that we swept at the TGMAs this year is just amazing. It shows how much work this man has put in it and very well deserving. Whatever is happening on Twitter and anything thereof, we really don't care. We're happy. This win is happy. This win makes me want to put in a lot of effort in everything that I do, because if you are a lover of Stoneboy, you'd appreciate great work, you'd appreciate creativity, you'd appreciate everything, every investment that's in it, and amazing performances yesterday. Yeah, I'm glad that my guests here are not very much, you know, they are not very much. In Sanka, we'll talk about Kim Promise, but it's okay. Let's talk about other matters. But congratulations to BIM, One God, Stoneboy, very well deserving. Now on that note, and many other and all other artists that have won something. I mean, Kim Promise. How many awards did he win? I wasn't counting, but at least we established that he picked some good number of awards at the TGM this year. Anyway, so today we are going to be talking about the ambulance case matter. So it started from somewhere, and it looks like we're going somewhere with it. We'll also have time, and then we'll talk about the digital expansion and matters arising as to how, as Lewusu, the Honorable Minister in charge for communications and digitalization, has been justifying the awarding of the 5G contract to a week-old company. Now, this morning, I'm joined by Julius Kwame Anthony. You know him already. I'm also joined by another good friend of mine, Ofe Clinton. You also know him as well. So, gentlemen, welcome to the show this morning. Clinton, it's been a minute. How have you been?
Thank you. I'm very fine. It's just that you don't really check me. I'm not part of your inner circle. So has that not been the case?
Oh, how did you arrive at that conclusion that you're not in my inner?
The last time that we have had any conversation was me initiating that conversation.
Oh, you'd love that I initiate the conversation. That's pretty simple.
I'm not saying that I would love that, but I'm saying that consistently. I mean, if you say
but
hi, what
you didn't send me any message after that. After you only sent once, and then that's it.
And then if I have sent once, and then maybe the corresponding response was maybe a little bit timid, I wouldn't be encouraged to proceed.
But why are you timid though? Don't be.
Yes. Okay. Let's squash that.
Okay.
We have reunited.
Are we?
Let's proceed in that direction.
Anthony,
yeah.
I like to talk about your outfit. What is inspiring this outfit today? Yes.
It's Doomso. It's Doomso. See, let me not lie to you. It's Doomso.
This morning.
Oh yes. I woke up this morning hoping I would be appearing before you in my usual,
Yeah.
But
I like this one.
If you appear in such a traditional, befitting outfit, and then you want to make it look like you wouldn't have put on such a fitting, beautiful outfit because you have to. It's just an option because of doing so. I don't think you are being fair to. I don't think you are being fair to our tradition.
No,
I don't think you are being fair to our customs and then our values as a Ghanaian. You where you come from.
But as a matter of fact, I like to comment ECG. Yesterday, I was sitting on the edge. I was still on the edge that, oh God, ECG, oh God, I just want to watch who would pick the artist of the year before if they're going to take
you were not having light at your
I had light, but prior to that, a day before and the days before.
We have made a lot of progress with our Doom CSA initiative. Initially, when we had encountered it,
we're not even complaining,
so all this interjection and about tradition and all those things ruining my introduction is about covering
I was only saying that if you have a traditional outfit like it, you don't just undermine.
He's not even allowed me to say what I want to say before
okay, you proceed.
So you have a problem already. And it's just to see. The point is this, okay?
If you make it a doom matter, then I have an interest.
It's a doom matter actually.
And usually a doom matter.
Ordinarily.
Hang on.
He's talking
today
about,
we must have very sanitized conversation. Today,
of course,
we would have.
Okay.
Okay, it is him and how he feels about his outfit. So let's allow him. Is that okay? Is that okay?
But I'm not saying
he's the one
anything
talking about tradition.
Okay.
Okay. Ordinarily, in our cultural and traditional setting, would you see a man wake up and just be in black, especially on a Sunday morning? Ordinarily.
I mean, you're taking us back.
Ordinarily. In our cultural setting, men just don't do that. And so when I am doing that, I am telling you that it is because of doomsday. I woke up this morning only to realize my lights are not on. My morning plans and everything is ruined. And so the outfit that I planned that I will come here with, I'm not in it. I have to just enter a black smoke. It's the readily available one that does not need ironing and anything.
That makes a fair point.
So I don't see why you make resort to me saying that I have to wear this out of doomsday as the degrading tradition. If there is anyone who upholds and loves our tradition, I think I'm one of the people who is very well known for it. So please, don't come and denigrate tradition and all those things as a way to cover up your doomsday and your failure. Let's face the relevant issues and move on. So this is a doomsday problem. This is a doomsday problem.
You're accepting it. That anytime that you get to see somebody in smoke, that means that
that's not what he said.
Why is he
that's not what he said.
I'm telling you, I am
I've got my marbles up, but that's not what he said.
On a Sunday morning, because I could not.
I'm a Ghanaian. I am black. If I choose to put on black, what has that got to do with it?
In our tradition,
but
in our tradition,
my favorite color is black.
What?
I can put on black at any time.
I love black too.
Yes.
But because you went into
so you
the
don't wear
conversation
black
of culture and
because you
tradition.
think there's a trouble somewhere.
No,
you don't wear black.
No, we do wear black. But okay, let's have our conversation today. Looks like
today I'm also wearing red.
You're actually wearing red.
So how are you going to interpret it? That I'm also going.
I'm sure by now he's dressed like this because of doomsday. But he won't say it. He won't say it because
my outfit actually needs ironing.
I'm sure.
Okay. Does it? Did you iron it?
I did.
Did you have light?
I have electricity.
Oh, it doesn't need
lucky.
Yes, and you too. You have it, right?
This is a Versace top.
Yes.
It's a jeans trouser. Wondering if it's original though. But
sure. Look at the labels.
You don't need to iron this.
I have to.
You don't need to iron
check
this.
it.
Okay.
That was just me being.
Yes, because if somebody sees you in a designer, they will. So I
iron your African print this morning. That's why I'm wearing this. But Napo is watching, so you won't say it.
But I have not been on the show with an African print.
So you won't say it.
Okay.
But we have addressed the doomsday matter.
I appreciate the conversations around doomsday. I'm not very excited about the doomsday conversations because I've had my fair share. If you live around Ashaliboche, it's horrible. But let's not have that conversation yet.
Another time
we'll have that conversation. So let me go to Anthony especially because after Mr. Richard Jakba, made those allegations, there have been many calls that he should substantiate the allegations. And yes, I followed the press briefing. I've also followed the audio that has been playing. Straight away, the NPP is saying that it's a doctor tape. First of all, I understand that as a country, our sitting government is the NPP. But I was actually surprised that it was the NPP that was responding to the opposition. Because the issues of the Attorney General is a whole government issue. And we cannot say that everybody in government is NPP. But that may be a long stretch for me. But I just didn't think that in the interim, if anybody was going to respond or talk about that matter, it would be the NPP because the press briefing said NPP. It didn't say that it was the government responding to our Attorney General, the allegations made by the Attorney General. But I can also understand that if government wanted to take a step back, it's well appreciated because these are matters that eventually we can't be our own judge in our own matters, so it's okay. But after you guys brought this audio out, the MPP says that it is doctored. Frank Davis, particularly leading this conversation, says that it is doctored. What really is the next step for the NDC?
Well, you made a very fundamental point about the MPP taking up a fight which is supposed to be a government or the Attorney General's fight. A lot of people have raised concerns about the fact that the Attorney General's office should be separated from the Ministry of Justice and all those things. But given the circumstances of the particular issue we are facing, I do not think that is even the issue. I think it's a matter of people just realizing that being in office is a matter of living according to certain codes of ethics and certain standards and being honest with the job and not pursuing other people by reason only of the fact that they're in a different political party, and so we must use our offices to persecute them. The Attorney General, if for nothing at all, has legal codes of ethics he's supposed to follow. The NPP is being funny, particularly to me, because even if they were to accept, I mean, without granting, it's false. The audio is not doctored. It is what it is. But were we to even accept that, the NPP has not at any point in time denied that Mr. Dami is the one on the call. They have not denied at any point in time that it was he who was talking to the person and all those things. I do not think that it's even ethical, okay, for a lawyer, for the Attorney General for that matter, prosecuting a case against somebody, to be talking to the accused person without his lawyer on matters relating to the trial. More so if you are discussing another accused person in that issue and on matters of witness testimony and all those things. That alone, the fact that they are not denying that he is the one alone, is a reason for which anybody with any shred of decency at all in him should resign from that office. What Mr. Dami is not understanding is that a prosecutor's job is not to secure conviction. I mean, the courts have been on record to have said it several times. Your job is to lay the facts as they are before the court. You are allowed to do that as forcefully as possible, but you must be fair in doing them. How fair is it to an accused person in a trial that you are talking to another accused person in the same issue with regards to witness testimonies and how they should be done and all those issues?
I mean,
how do you justify that you are even talking to an accused person in a trial at the back of your fellow lawyers who are representing them, and you are discussing matters about how the nature of their testimony should be and all those things?
Because they are suggesting that the tape is doctored, we cannot arrive at this, because the conclusion and the real tape then will suggest whether
there is no point where the NPP said that Mr. Dami did not talk to what do you call it?
They accept.
Yes, they accept that
he's talked. Yes,
they accept
but
that
they also say that it's doctored, and if the tape is doctored, we cannot substantiate the content.
He spoke to him outside of court.
Yes,
they accept that he spoke to him without his legal counsel. They accept all that.
They've been concerned that at the time he was not being represented.
Yes,
and they accept even without that, whether he's represented or not.
Does the law say that if you're not being represented by a lawyer, they can engage you? I'm not sure the law also provides that.
No, but ethically, why are you discussing witness matters?
Is it strange,
though? It's not what?
Is it strange?
Extremely. What was the Attorney General discussing with the person at home, over the phone, over the trial? You see, we should not even pretend that we need to even have a clear, what do you call it, conversation where he's saying that I want you to tell the judge this, even for it to be, before it becomes material misconduct. It's misconduct the moment the Attorney General feels that he can pick up his phone and call another person or a person in a trial and start discussing the trial with them when there's no process with regards to that.
So where's the NDC going with this?
You say?
Where is the NDC going with this?
The NDC is saying that Mr. Dami at this point is not a person with the right ethical standards to be exercising the prosecutorial authority of this state. He should resign. That is what we are saying. Based on the fact that, one,
conduct.
Yes, conduct. Two,
have you dropped the criminal part of it?
I mean, it's
because we're unable to substantiate the criminality.
How do you say they are unable to substantiate the criminality?
Are you people still pursuing there? I mean, because we would have to at least both intentions and the actors must be there. But what's the intention?
You don't see an intention of the Attorney General to persecute somebody. What about to the extent of talking to other people in the same trial to give witness testimonies?
What about Mr.
Jackman?
What's his intention? What was his intention when he was recording the conversation?
Because Mr. Dami would have denied it. If you were Mr. Jackman, knowing Mr. Dami, there are a lot of issues that point to the fact that Mr. Dami, when he is pursuing a criminal issue, goes with the intention of convicting people. The reason I'm saying this is because there was this earlier case. What's the name? Gregory Afoko and the Attorney General. When Mr. Dami was prosecuting this man, you placed this man under custody for years. When the trial was ongoing and he was getting to the verdict, when Mr. Dami realizes that he would be unable to secure conviction, he enters a nolle prosequi and then rearranges the person again. There has been several questions about whether the Attorney General's discretionary power to exercise nolle prosequi should be used that way. And that's an abuse of the process. Your job is not to secure conviction. And so to abuse people in that way reveals a certain pattern on the side of the Attorney General, that anytime he picks up an issue, it is with the mindset that he wants to secure conviction. And a prosecutor is not to secure conviction. His job is to lay the facts before the courts and let the courts render its verdict. Okay. So when he keeps doing these things, there's a pattern that he wants to secure conviction. And so when the same person goes about calling Mr. Jakpa and making suggestions as to how his testimony should go and all those things, if you are Mr. Jakpa, wouldn't you be wary about how you deal with that person? You put him on record so that eventually when he turns on you and he's pursuing you in that way, you know what to do. So that is the situation we are facing. We have an Attorney General who feels that his job is to use the prosecutorial powers of the state to witch hunt other people. And that is what he's doing. This whole ambulance issue, honestly, if we are to even look at the facts on their merits, because it's before the court, it's a criminal matter for that matter, and the Attorney General will be required to lay evidence.
Would you hold on to the facts, the merit of
but the conduct of the Attorney General so far, there is no doubt
we'll come to
about
the
ethics.
We'll come to
He's
the case with itself.
But this way. His job is not to go about witch hunting people and wanting to jail them at all costs. That's not his job.
A minute. How do we arrive at the conclusion that it is as if the Attorney General is on a mission to convict Attoforsen? How did we arrive at that?
Why? But if you are not on a mission to convict Attoforsen at all costs, why are you calling other people who are equally accused in that case and coaching them as to how to testify? Why are you doing that?
Okay.
Did
the audio, the press conference generally,
yes,
did it come to you as a surprise?
Yeah, it did not come to me as a surprise. Anytime that the NDC is kind of anticipate using, you people are students of the law, and many people also have the opinion of the law, and then they understand to a certain extent when a prosecution is getting to an end, and then they can determine the outcome. So they run to the court of public opinion to seek justification instead of going to the court. If you have, there is evidence.
The case was still ongoing.
Yes, the case is still ongoing, but both parties, defendants, have closed their case. You get it? So if you have any substantial matter to uphold, what you need to do is that you tender it in court as evidence. Is that not a procedure? Why do you have to come to the public and explain matters that are ongoing in court? If you do that, you ambush the court procedure.
But the Attorney General also speaks to the public about
let me. I never interjected.
Actually,
I was very peaceful.
Well,
so we're
fair
not.
enough.
So I see it is a very problematic of a character of the NDC that they would come to the public and create a certain impression as though there is certain sway of justice when that is not the actual matter.
Should we stay on this for a minute before we go to the next? Let's stay on this. Let me stay with you on that. And so we're aware that it doesn't seem to me that Mr. Jakpa, when he was in court, that he was going to open any can of worms. You would realize that per the transcript that we may have seen, he says that if you dare me, I will make my own conclusions by saying that if you dare me suggests that I didn't have that intention of wanting to speak in the first place until maybe I'm pushed to the wall where it's going to go against me. However, here's the catch. When that happened, a lot of people have asked that why didn't the Attorney General, respond in court? I also say that for lawyers, I mean, it is tactical. It is tactical. He didn't err by not responding or anything. However, we then later will see the Attorney General responding in public. Fair enough, because he holds the office for us, so maybe he felt the need to explain to us, the public. But you realize that the communique from his office sought to suggest that he has never sought any kind of help at all from this person who is alleging all of these things in court. And even went ahead to now release the plea bargains that the accused person or the big C company was hoping to get from him. So if we talk about whoever run to the public first, it really looks like, yes, the Attorney General, per the position that he holds.
Because of the outcome of the situation.
Which part of the situation are we talking about?
When Jakpa had to go to court and then create a certain impression that the Attorney General has been trying to influence certain decision procedure.
So why did he not also respond in court proceedings rather than?
What has happened was court goes in session. Maybe that day, maybe the court.
So why did he now write a letter to us?
So what will happen now is that now the Attorney General came to the public and just said that this guy who is making certain humorous claims that I have made an attempt to influence him have even reached out to me through several mediums to establish a plea bargain. Okay, and me, I haven't even seen where somebody has even determined the models through which an Attorney General can execute in his way of prosecuting a matter. He can even decide to file for a nollie prosecute, and he wouldn't explain the circumstances to anybody.
But that is still the power that's given to him. It's a law that is given to him. It's a power that by the law given to him. He draws his power
from the Constitution, Article 88, directly. So he's not even a subject to any professional ethic and like we are trying. Yes, he's not.
The Attorney General is not subject to
the GLC does not have jurisdiction over the Attorney General's office.
Anthony, this has come up, and I'm actually
curious about it. Because a matter of that nature has gone to the GLC, and they have declined the disciplinary jurisdiction.
Would you refer me to that matter? Would you able? Actually, whilst he's at it, Anthony, I also heard that, and I said, okay.
You see, the Attorney
you
General
get it. So the Attorney General, in his own capacity, doesn't draw his power. The GLC regulation, disciplinary regulations, is a subsidiary law. Okay, he has the supremacy law that he extracted directly from the Constitution. So you don't make him a subject to a subsidiary law. You get it. Granted that he has even flouted in that procedure, and then the General Legal Counsel should take certain actions against him. What can they do against him? Withdraw his license or what? Or debar him or what? Or not give him license to...
Well, surely we're not saying that the GLC will just get up and,
Yes, some of the disciplinary actions the GLC can take is what I have mentioned.
Pay if he falls short of the conduct.
Exactly. And even if you like, somebody should test the law and then submit this matter to the GLC.
Somebody, but he's our Attorney General, so who is that somebody?
People have created an impression that he might have gone out wayward with the prosecution. And where is our interest as a nation? Are we interested in protecting the public purse? Are we interested in fighting?
That's our interest. That's why people are confused why he won't take the plea bargain.
Also, why are we saying that Attorney General...
Would you like that he takes the plea bargain?
Why are you saying no? I'll get there.
Okay.
But why are we saying that an Attorney General who is fighting corruption at that magnitude should be set aside? If you know that you are not, just go to court. Let the matter finish. He is not an adjudicator. He is just a prosecutor. Okay, so he doesn't determine the outcome of any legal matter that is being taken to court. The judiciary have the sole mandate, sole responsibility, and authority to determine that. You get it? So I don't know why somebody feel like they are scandalized because Godfrey Dame is the Attorney General. It doesn't scandalize you on...
Can Shraj take up this?
Is it a human right matter? Has he abused? And even for Japan to have accepted... Look, if you think that it is legally not permitted for me to have certain kind of dialogue or expatiate certain conversation, why would you even accept in the first place to have met me here and there and then accepted the conversation to go on when you have even initially reached out to do a plea bargain? So we have established that connection of conversation. Anything might have come up later on, and that might have led to what we are seeing today. So I don't see any matter. I don't see any, because, like I said, the strategies that the Attorney General have that he can deploy to prosecute a matter. The
strategies are not outside of the law. He doesn't conjure them. It's not
outside the law.
Practice.
What you are accusing him of is is it a disciplinary matter or an ethic
professional
situation?
Conduct, yes.
And yes, and I'm telling you that even with that, he
and
doesn't
if they
fall
establish
short.
any criminality, he will be under Act 89.
There's no criminal procedure in what the engagement that the Attorney General has, at least per the evidence that is out there.
No,
if
but
you are able to analyze
to try and procure testimonies against somebody, it's criminal.
It is criminal.
You don't think it's criminal to try and procure testimonies against somebody?
Procure testimonies.
You don't think it's criminal?
Procure testimony from him. And that is why they have to put out a very questionable doctored tape out there. If it is substantial evidence, they should tender it in court.
Okay.
That is what we want to establish.
Okay,
if you have a
Anthony.
substantial evidence, there's a whole act
But did you
guiding
hear
the principle
Anthony?
of evidence.
Did you hear Anthony? Anthony says that whether or not the tape is doctored, it means that for something to be doctored, there was an original one.
Yes.
So now we're establishing that the Attorney General had a conversation.
The Attorney General have not denied that he has had a conversation.
And then so the MDC is saying that even just on the face of that, on what grounds are you having the
And
conversation?
the Attorney General have said that the conversation that might have transpired initially
was plea bargain.
Yes. And then
That's
another
what
point,
they were doing in the
another point,
the Supreme Court judge's house as well.
Supreme Court judge called the meeting.
Plea bargain is
Called
what
the
they have
meeting.
in
But you're aware
And
that
when
the plea
he called
bargain
the
act,
meeting,
but you're aware that
when he called the meeting, the Japa was in the meeting.
Hang
He
on.
was present
Let's take a
there.
step back.
And then there was another meeting there.
let's take a
So
step
that-
back. Let's take a step back.
So he
If we're
didn't
going to have a
initiate to meet
conversation-
Japa or
Hang on.
anything.
If we're
It
going
was
to have a
the
conversation about
Chief
plea
Justice who
bargain.
initiated the meeting, and then he
Sweetie.
called him.
Sweetie, do you know what? If you're going to initiate a plea bargain, whichever way, the Plea Bargain Act establishes how you can go about it.
It's a funny thing.
It
That's
does
a
not
funny
suggest
thing.
where it is very
It
strict
is done
on
the
how
phone
it
with
is
dummy
done.
when they talk
Do you
about how a
understand?
person.
In fact, the
giving
Attorney
testimony.
General does not have to have a conversation
But
directly
the
with
Attorney
the person.
General did not reach out for a plea bargain.
Whether he's the one that reached out or whoever reached out, they say you're not supposed to engage with that person. You must engage with the person's legal representative.
That is why he's directed that the person should have a legal representation or somebody, the main defendant, instigating that plea bargain so that he represents himself and then the matter can proceed.
So that's what was
That
discussed
was
in
what
the
in
tape.
the, that was what in the that
Before
was what was in the
NDC
conversation.
doctored it. Tell
Yes.
you people, why did you doctor? Why
Yes,
is
Well, I
the tape
mean,
doctored?
That is
who
what
doctored
happened.
what? You
I
see,
think that if they have a valid,
I
valid
even have a conversation with him
It's
alone. You
okay.
can
I'm
have
sorry.
a
I
valid-
think you've had a good
Yeah.
time.
You
I
can-
haven't-
you
I haven't
can
had
let
my
me know
time.
so
Oh,
that.
Why
come
is
on.
it that
I think
you
now
have
I'm going to type. I'm going to be typing the time now. You have had a good time.
I have not
Let me,
had
now I'm
my time. How
timing
many
it.
minutes did you allocate?
So we are going to spend time
No, it's
doing that
okay.
one
Let's
as well
go.
differently.
Let's go.
What
Let's
about
go.
you?
Oh, but no, it's
To
not
be
about
fair,
an
to be
attitude.
fair,
If you
to
are,
be
you
fair.
have been seated here and then you have been allocated
Talk to
a
me.
viable time for you to
How
have.
did you, have you been hearing yourself?
Yes.
Do you know the amount of time? You do know how
I
much time
haven't
you've been
spoken
speaking?
for a lot of time. I haven't spoken about like
Okay,
2 or
land.
3
You
minutes.
land.
You get it.
Land.
So what I'm saying is that the NDC don't have any matter to prosecute. What they want to do is to create an impression because they know they can actually see. Because recently we have prosecuted the former Maslok post, and they know where the wind of justice. They know how it winds, and then progressively they know where it will end. I mean, some of you are students of the law, and then you can equally anticipate an outcome of a judicial
Is
matter.
Anthony that? Have you been taught how to anticipate the outcome of a?
I don't know where he
Because-
learns that.
Yes, you can anticipate if you follow the procedure.
You will not
and
be in
then-
contempt of court anyway.
Yes, I'm not saying that okay, this is the actual verdict, but I said you are
You
anticipating.
can anticipate it.
You get it. Like you can predict and get it wrong anyway.
Okay, I'm waiting for you to sincerely land. Let me
Okay,
know.
So you
will
can take it over.
Okay, thank you. So
However,
yes,
it's funny that we are making an issue of witness tampering of a sort by the Attorney General, a light matter to suggest that because he draws his powers from the Constitution, he is above ethics. What, excuse me to say, nonsense is this? The Attorney General is above ethical conduct simply because his
I
office
like to
has been
think that's not
provided
how
for.
he meant it.
That's what. Oh, MFA, please.
I like to-
My friend.
The
You
legislation that you are subjecting.
MFA, we are going to do this
legislation
thing.
that you are
I'll just have to
Hang
go.
on,
I said
Because
that
I'm tired
the
of
GLC
it.
doesn't
Hang
have
on.
any jurisdiction
I'll
over
just
that
have to
matter.
go.
So you
Hang
cannot
I'll
subject
just have
him
to
to
go.
that.
Because
So
when he
even
was
if-
speaking,
Even
Hang
if
on.
that is the matter.
I'm
discipline your
moderating
guest
it.
because it's been
I'm
one too
moderating it,
many.
don't
Anytime
worry.
you're on a panel with him, it's the same thing every day. He asks for equity, does not want to exercise it. I'm not going to deal with that today.
Okay,
So he better knows that.
okay. I think I'm going
That's
to.
why for over 10 minutes I've watched him make his statement.
I
I'm not
didn't
going to
talk
deal
for
with
10
that.
minutes, but you can.
I'm not going to deal with that today.
Do you guys need some water?
I don't need water. I just need somebody to be disciplined a bit.
Wow.
Enough of that.
I mean,
if once every single day he does that, I'm tired of it. And I know he was coming out because it's
trying to attack you. That is unacceptable.
You okay, both of you.
Like almost every day. Why?
No.
You see,
no, that's
if you have a problematic upbringing, don't bring it here.
Really?
Okay.
You can't keep quiet and let somebody make a point.
I can't keep quiet for
what?
If you have a situation that you are dealing with that you cannot control, don't bring it to me.
Really?
You are dealing with a course. You don't have any personal matter with me.
Yes, that is why you.
Both of you, but you are not listening to me.
If the issue
You both
is
are not
about
listening to me. But no, Anthony,
no,
come
if
on.
the issue
No,
is address the guest, don't attack me.
Okay.
Even if you are not going to go.
Every day is like that. If you have a different guest, I'll come.
Okay, guys, let's go for a quick break. We'll be back.
When the news breaks, when decisions are made, when society says it has to be a certain way, as young people, are we ever part of the conversation? Hi, my name is Emefa Akosia Adeti, and I invite you to be part of discussing relevant issues, be it social, political debate, religion, or culture. Let's have our say. On Youth Connect, we shall spark conversations, challenge what we ought to, and find solutions that benefits us all. On Youth Connect, we shall bring to the fore your passion, most importantly, your voice. Don't just watch or listen, act. It matters to you.
Hi guys, welcome back. So just before we went for that quick break, Clinton was making a few points that I think that Anthony also wants to bring some clarifications to on the side of the NDC. So let me hear you. So one of the take homes from Clinton is saying that that instrument or the legislative instrument that you want to use in tidying up this whole matter, as I do not want to use any legal terms, would not be. He says the Attorney General is insulated from that, and that will be the professional conduct as the GLC would require. And it's not just Clinton that's saying this. I have heard many lawyers on the side of the NPP say this. Many people that have, high opinions say this as well. And then I'm wondering, how is this? Because then to be an Attorney General, you must be a lawyer.
However, the fact that somebody's office is created by the Constitution, and even we grant that the person has a certain insulation, does not take away the fact that there is an issue of ethics and conduct to talk about. Do you know that the President of the Republic can walk into this room right now and shoot you, and he's not subject to prosecution because of Article 57? Yes, he can enter the room right now with a gun and shoot all of us and still walk away, and nobody can even arraign him because he's not subject to prosecution. But does it make any sense that the President should be able to do that? Does it make any sense? So anybody who makes a proposition that because the Attorney General's office is created by the Constitution, and for that matter, he is not subject to the codes of conduct of the General Legal Council, which means he can go about and misbehave, must not be sane. Because if you are saying that because of
sense or
my friend,
I'll give you,
why don't you have
I'll give you the time.
Like why?
I'll give you the time. Okay. Are you able to note? You can note it on your phone. Okay. I'll give you the time. All right.
To make that proposition is to lack sanity, to be honest. Because how do you propose that because somebody has a constitutional insulation, because his what do you call it? His office is created by the Constitution, and there is no clear stipulation that he should necessarily even hold a license to practice and all those things. It means he can misbehave. How do you make that proposition? And so if you don't speak to the issues as to whether or not his conduct is warranted, as to whether or not his conduct is germane, and you start making resort to the fact that he is insulated by the Constitution, it's an admission of guilt. Do you know why that's an admission of guilt? Do you know when a person would make recourse to the fact that I am protected by law against something? A person will only seek indemnity when the person concedes that there is a wrong.
Okay.
So why are you running to indemnity if there is no wrong?
So that
is what I need us to speak to. So when you hear them talking about the fact that, yes, per Article 88, there's no requirement that he should even be holding a license. So even if the GLC revokes the license, he will still continue. It's an admission that they have done something wrong, or he has done something wrong. Why are you running to your insulations? Why are you running to indemnity? Why are you running to justification?
Perfect.
If there's nothing
wrong. So let's
wrong.
talk some law.
And so it doesn't make any sense for anybody to say that. So the Attorney General's conduct, there is a misconduct which must be addressed. Speak to the misconduct. If you cannot speak to the misconduct, you should admit the misconduct. If you can speak to them, it's conduct, let's have the conversation. But the moment you start talking about the fact that he has this immunity or the other, the only reason why a person will make recourse to immunity is to admit that he has done something. If the president walks into this room and shoots the three of us, he will make recourse to Article 57 and say that nobody can prosecute him. That, in the first place, is an admission that he has done something, but his immunity avails him. So if you are making recourse to immunity, it means you have already done something wrong. So let's speak to it. What has he done? What he has done, is it ethical? Is it allowed to be done for the Attorney General to call a person who is an accused, a co-accused with someone else in a case? I want to land this point, a co-accused with someone else in a case. Take the person, to a justice of the Supreme Court's house. Make phone calls with the person, discussing the trial. Is it ethical for the Attorney General to do that? It is unethical. The Attorney General is a lawyer, and the ethics of any lawyer guides him as well. The fact that he has a certain insulation as Attorney General does not mean that those ethical issues should not be discussed. So let's not go on that tangent. And then secondly, there has been an allusion that by merely making an attempt to secure a plea bargain, Jakpa has opened up himself to be used as a pawn or whatever in convicting, what do you call it, the majority leader, Kisela Tuforsen. If I reach out to you in exercise of a right which is available to me by law to get a plea bargain, what does that, come in, or how does that come in as a justification for you reaching out to me to bear false testimonies against somebody? How does that justify it? That I reach out to you to exercise a legal right means that I have opened the window for you to come in and exercise unethical conduct. So if we bring in the issue of plea bargain and the person reaching out to seek plea bargain, a right which is accrued to the person under legislation, as a justification for why the Attorney General can make those propositions, again, it must come from insanity. And that is why I'm saying we should not allow that over here and start making recourse to immunity. If he has any immunity and you are saying that he should exercise that immunity, it is because you have admitted there's something wrong. If there's nothing wrong, you will not be pleading immunity. The only circumstance under which the president, for example, will make recourse to his Article 57 immunity, it is when he admits that, yes, I have done something, but the law protects me against you holding me accountable. So is he admitting on this platform right now that by saying that the Attorney General is insulated against, what do you call it, disciplinary procedures by the GLC, there's an indisciplined action or an ethical action on his side?
Let's just say,
if you start making that, it means that you are admitting that
he's not the one admitting, but let's just say that's the conversation. I'm saying that.
No, I'm responding directly to what he said about the fact that there has been there's already precedence that the Attorney General is not liable to such proceedings. Is it an admission that he has first acted unethically, that there's a disciplinary action against him?
If there's an admission, then what happens? What laws will we then invoke?
If there's an admission that he has acted unethically, then it goes to lay credence to the fact that the Attorney General is in pursuit of unjust conviction of somebody. Because if you are not admitting that he is in pursuit of unjust conviction of somebody, why are you making recourse to the supposed immunities available to him? That is the question.
No, because that's the instrument that you people want to invoke.
Yes, and we are saying that.
First of all, they are saying that he said he's done nothing wrong. Yes, that's my voice on there. It's doctored. If I were a judge in this case, I would say that. Well, I appreciate. I hear you, but how long is the tape? Did you say how long is the tape? Is that all of the tape?
I am unable to speak to what else is there or what is not there.
Okay.
But what we know for a fact is that that is the Attorney General's voice in that recording. He's the one speaking in that recording. Apart from members of the NPP coming out to say that it is doctored, there's nobody, a body or institution which any requisite integrity that has come to impugn that. Indeed, the MPP making those suggestions has been countered by people of equal repute. Professor P.J. of the University of Ghana has come out to say that, see, what we hear on that recording, you should resign. Imani has come out to say the same. All these people have come to express that view. The MPP, which is expected to at all costs defend anything done by a member of the party, will not be an authority on the matter.
And that is why I'm saying that does not even matter.
Why does the audio, it matters? It is the MPP that's saying it doesn't matter. That they could go ahead and the Attorney General can go call people, and then the only justification they have, why is doctored. As for saying something is doctored, anybody at all can open his mouth and say that. Any idiots can open their mouth and say something is doctored.
I'm really looking
But
at
the
time.
question
Time
is
up
that
now.
the Attorney General, is he supposed to be calling witnesses? Calling accused persons, co-accused persons in a case, and asking them to testify in a particular matter?
I think it's a
He's not
question that
supposed
you
to.
guys have asked
He's
many
not supposed
times in
to.
a
And
row.
so if we are saying that the conduct is unethical, if we are saying the conduct is improper, speak to the impropriety. Speak to whether or not the impropriety exists. The moment you start making, allusions or deferring to immunity, it's an admission that you have done something wrong. And that is the point I want to emphasize.
Okay. Clinton.
It's interesting, you know. If you want to accuse me of something, and there is no existing legislature to prosecute me, then you cannot say I'm guilty of a crime. If that is why we have criminal instrument, we have criminal act and code that stipulated that if a person commits so and so crime, this is what we can use to pronounce, define. There's a dictionary to define certain crimes and certain actions and demeanors, misdemeanors or whatever it is. You get it? So if you cannot establish that there's an existing legislation that is the Attorney General can be subjected to, you cannot hold him responsible for any misconduct.
So they're saying that there's an existing GLC. However, because he's the Attorney General,
exactly. So
you guys are saying that.
So there's an existing GLC is not within that jurisdiction to pin him. So let's consider it as there's no existing ally for him.
There's an existing ally, but he's immune, as you have said.
Yes.
We cannot suggest that.
No, if there's existing ally, why is he not is he not subjected to that? The ally is not. It does not include him and the members of his office, as example like state attorneys. These people that he has allocated or delegated his powers to, they are not all subject to those GLC subsidiary law that says disciplinary professional act. They are not subject to that. Okay, so if you want to think about institutionalizing or creating a separate act to handle some of these issues, so-called issues of unprofessional conduct, then we should think about that kind of dialogue and then see how we can create something like that to include him into that bracket. Okay. Until then, if there's no law making him guilty of what misconduct that you have labeled today, then you cannot call him guilty of anything, any misdemeanor, any misconduct, any unethical principle.
Okay. Okay, so at the moment, let's just say, if this tape comes out, we have technical people, and then they check, and then they say that no, it's not doctored. There's much harder evidence because the man says he has a lot of evidence. Then, are we saying that? Oh no, well, we're learning. Are we saying that we don't have any provision that we're not predicting, we're not preempting anything. We're learning. So because I initially mentioned that if we can't go under GLC, will Shraj have any means? If you look at the functions of Shraj in Article 218,
like he had said, initially he said that the very arrangement
when he lands up,
the very arrangement that existed for them to even engage was that
are you ignoring the fact that he's not speaking to whether there's an ethical conduct? He's saying that the person is not part of the people who can be disciplined by it. But he's not speaking to that.
I think he's speaking law. I think he's speaking law.
How is he speaking law?
Can you allow me to make my point, please? Respect.
Yeah,
I think this time we can agree.
Yes.
Right.
To be fair.
Yeah, we can.
To be fair.
I have the discipline.
To be fair.
You.
Please be guided.
And then, like, okay, so like I was saying, you see that the engagement started with Jakpa. Is that the name? Right. He was he triggered an instrument of the law to get a plea bargain. So that was where the conversation with him started. So if you are saying that the Attorney General was not supposed to engage him, it is Jakpa who initiated the conversation. So who engaged who?
Okay, and I was with you, but at this point I may have to. The Plea Bargain Act does not suggest who initiated or who started or who didn't.
So that is why a directive was issued by the Attorney General that if you want such a thing to be as an intervention, this is the models that exist for you to follow. And he directed that in a conversation.
How is that related to a conversation?
You get it? Yes. So if you are saying that the Attorney General must.
We saw that. We saw that the plea bargains that were initiated on behalf of, I'm not too sure if it is even for Jakpa, but
the first defendant.
Yes, we can see clearly that it followed the due procedure. It was the Attorney General's responses that said that no,
It did not follow any. If it had followed a due procedure, the Attorney General would not suggest the otherwise. He had said that if you want to trigger a plea bargain, you don't trigger it on behalf of somebody. Let that person that want to trigger the plea bargain come forward himself. Or else you deny accepting that he had initiated that kind of plea bargain.
This is a part I have to go and look into,
yes.
Because I would have thought that.
Yes, so that is your thinking. If it is a general thought, then we have to substantiate it with the existing legislation that guides these principles. You get it?
There hasn't been any is or that about where the plea bargain procedure that was triggered, either by Jack.
No, I am talking in the direction to who initiated, like he has said that you are not supposed to talk to somebody that you are prosecuting and all of that.
So if I understand, maybe the Attorney General on phone was not telling him that this is not how to...
Exactly, that's the point that I'm trying to make. That's exactly the point that I want to make. So this is not a significant professional matter that we haven't seen in this jurisdiction.
Have you listened to the tape clearly?
I have listened to it because I have seen truncation, doctored, and a lot of cutting in the. I see that it doesn't have any. It doesn't even have.
That we're discussing, there were LCs, not even plea bargains.
Any credibility. You cannot hold that thing as evidence. If you have substantial evidence, then that is in court. That's basic. Why are you submitting it to the public that, hey, listening to the tape, there was an engagement, that you can easily make a case with that in the court?
But it does not suggest that they will not take it
to court. No, if you take it to court, what is the essence of bringing it to the public domain?
No, because the Attorney General also responded to us.
Go and make your case. After the case has been substantiated in court, then you have a viable platform to even make a claim that this evidence has been tendered in. You get it? But evidence that has not been tendered in, evidence that its credibility has not been tested, then you are moving around with it. You
so
make
in
people
conclusion,
point loopholes into it.
So in conclusion, you admit that you hear the Attorney General's voice in there.
I have heard it, yes.
But you also admit that
he has not denied anywhere that there has been engagement between him and Jakpa.
Okay. But you also think that it is based
there
on
was an engagement with him, with Jakpa at the Koliondi, right? Kolindi, yes, residence. You get it?
Yes.
Yes, so he has made a lot of admission to substantiate the claim that he has had an engagement with him through certain medium. That is not so controversial. But because they want to find an escape, but what has this thing even got to do with the prosecution? You have even closed your matter.
This does not have any bearing on the case.
Yes.
If this is substantiated, it has no bearing on the matter.
It does not. It wouldn't.
You don't think that if the court happens to find an interest, because don't forget that the courts said that it should be recorded. His allegations should be recorded.
Yes.
Which means that it will have a certain, no matter what, it will have a certain bearing on the substance
so
of the substantive matter.
So let the court take that decision. Let the court take that decision. Until then, we cannot see the essence of it.
Okay, then we shouldn't be having any. We shouldn't have chairs and tables discussing anything. If we leave everything to the court.
That's why no. If I can have my opinion, you can have yours. You also can have yours. So if the chairs are very necessary because opinions are not the same.
That's so true. In wrapping up, because I'm gonna let me take your wrap up.
So I am saying to the NDC today that Attorney General there is for the interest of the state. What he's doing there, they are saying that when they come, they'll fight corruption in a certain way. He's doing exactly that.
Okay.
People who have squandered government. How is it even difficult to buy ambulances? Kumsin, yes, bought 360 ambulances
on the same precedence of Attorney General's purchases.
You get it? Yes.
On the same.
Yes.
So if you find this case problematic, that means you would have to go after Hawa Kumsin.
No, Hawa Kumsin bought the ambulances. It was inspected. Procedural facilitations were made, and all of that. And we have seen the ambulances. Go and buy. Did you see any ambulance? It is so sad that we were running a nation with not a single fleet of ambulances. And then somebody has squandered the money meant for the procurement of ambulances. And then today we are sitting here that the Attorney General ensuring that there's accountability for the money squandered by our two forces. You are saying that
do we want the money or we want him prosecuted?
We want him and the money. Anyhow, we want him. If we don't get to that, if we don't, yes, if we don't.
Okay, that's it?
Yes.
Okay, thank you, Clinton. Please have the rest of the minutes.
MFR, there is one thing that, for me, honestly, I find necessary to interrogate. And that is the issue of us not speaking to the substantive matter over here. What the Attorney General has done first there's a denial that he had no conversation with Jakpa on the subject. Second is that it is Jakpa who approached the Attorney General first, and the conversation is about plea bargain. Plea bargains are done within the remits of law. The procedure for actually making a plea bargain is clearly spelled out by law. How do you link that to the Attorney General calling the person to have a conversation about what testimonies to give? How are the two things related? And sincerely, I feel that should be questioned on this platform. How the audio, because or if necessary, you should have to play the audio. If he hasn't listened, we'll listen to it again and see how it is related to the plea bargain. Because for you to suggest that by exercising my legal right to make a plea bargain, I've opened myself up to have a conversation about witness testimonies and all those things, and so it is okay, it doesn't make any sense. Then the second point is that you keep insisting that the Attorney General is not subject to the code of conduct of, practitioners as lawyers or a prosecutor. How do you in one voice say that by the fact that he is simply not subject to it, because you make allusion to the fact that he is appointed per Article 88, but because he's appointed by Article 88, he can do anything he likes, and he's justified by that? What proposition is that?
It won't be the people.
It's not a problem with our laws. MFI, I made an example. I made a clear example that if the president walks in here and starts shooting us, is it proper?
If it's not proper, what then will happen? That's the question I've been trying to ask.
So the fact that nothing would happen means it's proper. I mean, the two things are different.
So you see,
is it proper? I have a legal immunity to prosecution for a period.
For 3 years.
And so within that period, I can go about. Shoot, it's
immunities. Yes.
You said the Attorney General is above that
immunities.
But you're not.
The Attorney General have not triggered any immunity.
You are the ones saying that the Attorney General is above the GLC's procedures because he's an Article 88 appointee.
The fact that he's above that doesn't mean that he has immunity. Maybe there's a certain legislation that if the legislation doesn't exist.
In the end, that's what it means.
No, if the legislation doesn't exist for him to be disciplined, like you have instigated for him to be taken on, then I don't think that there's any wrong.
You are taking
so if the president
I'm allowing because it's quite preposterous.
If the president wants that, and then he can shoot anybody here, and then he can walk out free, then the Constitution have made it so. Okay, then there's no existing law holding the president responsible.
So it's not the same thing you are saying that there's no existing law holding the Attorney General, which means he can do anything he likes.
Establishing certain laws that would sort of barricade that process.
So how you get it? Or what do you think? Is the same? What we say is the same thing. We're not suggesting that. I'm not suggesting that the audio that we listen to is true. The accusation is true. I'm saying that if anything related of that sort, what would we trigger for the Attorney General? I'm just learning from you that clearly it looks like the way it is, he's quite immune to anything that we may trigger under professional conduct. And people have been asking, you must be a lawyer before.
What is there in the indemnity clause? What does the indemnity clause say?
But you are the ones, there's no indemnity clause specifically written for the Attorney General.
What's indemnity clause? MFA, please, you should tell us what indemnity clause is.
Shut up, I'm talking.
It's my turn, and you can't tell me to shut up.
You can't say that.
You can't say that.
When he said stupid, you said stupid on the show.
You did?
He said stupid on the show.
You did? I promise that I didn't hear.
You didn't hear.
I promise. I promise.
I
You can't just say that word.
Who should shut up? It's my turn. You understand that? What indemnity clause? MFI should tell us.
I'm saying that if there is an indemnity clause, if there is an indemnity clause insulating people from certain actions or
yes, refer us to it. That's what we are asking.
Then we have to. That is why I'm saying that. What is it?
Yes, so what is you tell us? You are the one saying it.
What the
president asked you.
Okay, let me answer.
Tell us what indemnity clause. What law?
Let me
answer.
I'm
asking here,
what indemnity clause?
Why are you asking me? Why are you asking
in what law? In what law?
Let me answer.
In what law?
Let me answer. Both of you, let me
answer.
In
what law?
What law? I mentioned indemnity. She mentioned it. Why are you not the one who mentioned it?
You see, if you know nothing about the subject matter, then don't just come and say
what is it?
What indemnity clause? In what law?
No, I asked what is an indemnity clause. What is in the indemnity clause?
In what law? What indemnity clause? You say what is in the indemnity clause? Which if you use there, it means you know a particular law. In what law?
I am saying that I'm asking her.
there, it means you know a particular thing. In what indemnity?
In
what
the
law?
indemnity clause.
Yes, in what law?
Guys.
In what law? Like what you are trying? What are you trying to say?
In what law?
In
Which
what
one is
law?
the
No, I'm
Thank
not
you
asking
for
you about
watching.
the law. I'm saying that what is the indemnity clause?
The indemnity clause.
When the news breaks, when decisions are made, when society says it has to be a certain way, as young people, are we ever part of the conversation? Hi, my name is Emefa Akosia Adeti, and I invite you to be part of discussing relevant issues, be it social, political debate, religion, or culture. Let's have our say. On Youth Connect, we shall spark conversations, challenge what we ought to, and find solutions that benefit us all. On Youth Connect, we shall bring to the fore your passion, most importantly, your voice. Don't just watch or listen, act. It matters to you.